Right? Civil liberties, Bill of Rights, First Amendment, religion, and we're going to talk about the two clauses of the First Amendment that deal with religion, and it is the Establishment Clause and Free Exercise Clause. But before we get in a discussion about religion, I want to introduce you to the reason why we have the Bill of Rights and how the Bill of Rights is now applied on a case-by-case basis to state governments, and of course it is a protection from the federal government as well. So the Bill of Rights is meant to protect our civil liberties. Okay, so American civil liberties are set down in the Bill of Rights, and these are your individual legal protections from the government violating the things that you hold dear as your freedoms of things that you can do on a daily basis. So the First Amendment is your protection of freedom of speech, your freedom to assemble with people that you like, your freedom to petition your government to change what they are doing, your freedom to practice a religion, or your freedom to be free from practicing a religion. Right? And that's what we're going to focus on in the next couple of notes is the First Amendment and the First Amendment only. Okay, so the role of the Bill of Rights in the First Amendment is to make sure, like I said, that Americans have these basic freedoms that we value on a daily basis protected from the government taking them away from us. It is up to the courts to arbitrate these liberties and interpret their meaning. So arbitrate means to listen to arguments about whether or not people feel like their rights and their freedoms have been taken away from them, either by other people taking their rights or freedoms away, or by the government taking their rights and their freedoms away. And the courts are going to listen to those arguments. So that's what it means by arbitrate. So the courts arbitrate these liberties and interpret the meaning. Now, the thing is that yes, you do have freedoms and you are protected to be able to exercise those freedoms, but it's up to the court to make sure your liberties and the practicing of your freedoms and your rights don't harm other people or hurt other people or conflict with the public good. So if it is, you consider it your freedom of speech to, protest wealth inequality by setting mansions on fire. That's not a protected freedom of speech, because in you exercising your freedom or your liberty, you're taking away somebody else's right to property. All right, so that's what the court does, is balance people's liberties with the public good. Now, the original purpose of the Bill of Rights was to convince anti-federalists to ratify the Constitution. Even though James Madison tried to explain that states had their own constitutions with their own liberties and freedoms protected within the state constitutions, and we had checks and balances and separation of powers, and there were things that the government couldn't do to you, and he tried to convince the anti-feds that the Constitution was enough. The anti-federalists still wanted the Bill of Rights. The Bill of Rights in 1787, the purpose was to restrict the power of the U.S. national government only. It wasn't intended to be applied to the states. So the first 10 amendments in 1787 only checked the power of the federal government. And that was tested in a court case in 1833, Barron versus Baltimore. In this case, Barron, the Barron side of the argument, the petitioner, was having property taken away from him through eminent domain. So that's when the government takes property away from you and should compensate you for that property, as long as it's being used for public use. So Barron was having property taken away from him by the city of Baltimore. And he argued that in the Fifth Amendment, you have protection for eminent domain, that the government has to compensate you if they take your property, and it has to be used for public use. Well, so he sued the city of Baltimore, and in 1833, the Supreme Court said, look, I'm sorry, Baron, but the Bill of Rights really only applies to the national government actions and not the states. So we really can't do anything to help you out against Baltimore because the Fifth Amendment really can only protect you from the things that the U.S. government is trying to do to you. So the Bill of Rights is applied to today. Well, since 1833, there was a very important amendment added to the Constitution, the 14th Amendment, which came after the Civil War. And there's an important clause in the 14th Amendment, the Equal Protection Clause, which states that all states must protect all citizens' liberty. Every citizen of the United States has equal protection under the law or a right to due process. So due process meaning that if the government is going to try to take your life, your liberties, or your property away from you, there has to be the appropriate legal proceedings in place before you are put into prison, or before they sentence you to death, or before they take your property away from you. Okay. Now, the 14th Amendment says that states also have a responsibility to protect individuals' due process. Of course, the 14th Amendment, when passed or when ratified, really, if you were to be a strict constitutionalist or constructionist, the 14th Amendment would apply to recently freed slaves. But in 1922, or 1925, the court had an opportunity to interpret the Equal Protection Clause and see if the Equal Protection Clause could allow for the Bill of Rights to be applied to state government actions as well. And that case was Gitlow versus New York. So in this particular case, Gitlow was operating a questionable newspaper. It was a little bit communist, a little bit treasonous. The city of New York shut him down. He argued that New York shouldn't be able to shut down his newspaper, his magazine, because he had freedom of speech. And the court agreed the court agreed that the state and city governments shouldn't be able to suppress somebody's freedom of speech. In that ruling of Gitlow versus New York was the establishment of a very important doctrine called selective incorporation, where the court used the 14th Amendment to say that parts of the Bill of Rights are going to be applied at the state level. So the state has to comply and follow parts of the Bill of Rights, but it would be determined on a case-by-case basis. So if you sued the state and you said the state is violating my right to be free from unreasonable searches, Fourth Amendment, and the Supreme Court said you are correct, so now the Fourth Amendment applies to the states as well. Okay, so that's what makes it selective, is that we're selecting parts of the Bill of Rights to be incorporated into states' actions and local governments' actions, but it has to be done on a case-by-case basis. That's kind of what's going on. This is what the diagram is about. So here's the Supreme Court. It's taking a sponge, and the sponge is labeled the Due Process Clause of the 14th Amendment. And it is soaking up the Bill of Rights in that sponge, and taking the sponge over to the state and local governments and squeezing the sponge out, which is part of the Bill of Rights, on a drop-by-drop basis. Now, the parts of the Bill of Rights that have been applied to state actions at this point are the First Amendment, the Fourth Amendment, the Fifth, the Sixth, the Eighth, and the Ninth. Now, the effects of this, the effects of using the Due Process Clause in the 14th Amendment to apply parts of the Bill of Rights to the states on a case-by-case basis, is that practically all of the Bill of Rights is now applied to the state. And really, you can thank Chief Justice Earl Warren for that, because a lot of the rulings under the Warren Court applied a lot of the protections of the Bill of Rights to state actions, especially for those rights of the accused. Okay, now we're going to switch gears, and we are going to do, in the next set, we're going to talk about freedom of religion.